Okay, so I'm just going to start. Hopefully, the technology is going to be kind to me today. Sometimes we
I
have
reckon it will. I think
a
it's
few,
there. You've got
a
it.
few challenges. Okay, so lots to take into consideration. And I'm going to start with the changes in date order because I think that's probably the easiest thing, which means so you do have to wait for the unfair dismissal discussions, which is probably one of the main things that you want to know about. But let's just go through what's happening. So, as you're aware, the Employment Rights Bill has been tabled pretty much as part of the manifesto and obviously before the government change. And on the 18th of December last year, it was converted into the Employment Rights Act or amendments to the existing Act when it received royal assent. This Act, as I'm sure you'll be aware, will introduce a wide variety of additions and amendments to the existing legislation. And it will also be over a period of 2 years that a lot of these changes are going to take place. There's a lot that's happening this year. There's a significant piece happening in January 2027, and then there are further anticipated legislative changes that will also come into play. We still don't have a lot of the detail that sits behind this in terms of codes of practice. So again, some of this is a little high level, it's a little bit second guessing, but we do have the main headlines. So if we look at what's coming in to start with, for some of you, trade union reforms won't apply. You may not even be particularly interested in it. But for those of you who are of a size where trade unions could apply or already integral within your working environment or are knocking on the door to be part of the working environment, then this is quite important that you're aware of the reforms, and they take place next month. So what are the things that are coming in? So if you dismiss somebody for taking part in industrial action, that's going to be an automatically unfair dismissal. That means there's no service requirements for that. The changes that are going to come in February are actually going to repeal the strikes, the Minimum Service Levels Act 2023, and also it will repeal the majority of the Trade Union Act 2016. Some of it will still apply. When the bill was first put through and received royal assent, the trade union reform changes that are coming into play now had 2 months basically to be introduced, which is why we're looking at a February introduction as opposed to an April or an October introduction, which is when most legislative changes take effect. In addition, with the dismissal for taking part in industrial action becoming automatically unfair, at the moment, you have a 12-week window for claiming that. So, i.e., if the industrial action goes on beyond 12 weeks, you lose the right to bring that claim. So that's now going to be removed as well. The time to give notice of industrial action at the moment is 14 days. That's going to reduce to 10 days. So 10 days ahead of that industrial action, you would be notified. There's going to be a big change in the way that the unions can canvass for voting and balloting for various action that's going to take place. And that's going to change where they'll just need a simple majority to vote for industrial action. Picket supervisors are no longer going to be required in order for that industrial action to take place. And in the future, industrial action mandates will last for 12 months instead of currently 6 months. In addition to that, industrial action and ballot notices are going to be simplified, and political fund rules will change. At the moment, members have a choice as to whether or not their fees can be put into the political fund. They will no longer have that choice in the future. So lots of changes in respect of that. In addition, in April, there's going to be a simplified trade union recognition process, and there's going to be the introduction of electronic and workplace balloting. The government earlier this week have already just produced their draft revised picketing code of practice, if you're interested in that. and also a draft revised code of practice on industrial action ballots and notice to employers as well. And there's various other guidance that's being produced in respect of all of this. So if we look about some of the statutory increases that are coming into play, you may already be aware of these. They were publicised at the end of last year. So under the Employment Rights Increase of Limits Order, the statutory payments for maternity, adoption, shared parental bereavement, neonatal care pay are going to, the weekly pay is going to be increased to £194.32p. And the average gross weekly earnings required in order to qualify for that family leave pay is going to be increased to £129 per week. Statutory sick pay is going to increase to £123.25. I'm going to talk a bit more about statutory sick pay and how that's going to be calculated in a little bit. So that's all effective from the 6th of April. In addition to that, the national minimum wage will increase. Some of these increases are quite significant, some of them are 8%. So for those who are aged over 21, it's going up to £12.71 per hour. For 18 to 20-year-olds, it's going up to £10.85 per hour. And for 16 to 17-year-olds, it's going up to £8 per hour, as is apprenticeship rates as well. Again, effective from the 6th of April. It's worth noting as well the real living wage, which I haven't actually put on here. So this is the cost of living wage. So it's not a statutory obligation to pay it, but it's more of a awareness of it. And obviously employers are encouraged to pay it. So that's going up to £13.45p per hour for the UK. And in London, that's going up to £14.80. And that's based on actually what it is believed that an individual needs as a minimum in order to live off. And a lot of organisations embrace the real living wage and will try and make sure their hourly rates affect that or follow that. So if we just look at in a bit more depth around some of the other changes that are coming in. So as you may be aware, the sick pay changes, so we've produced what the figures are. There are other changes that you need to be aware of too. So the right to statutory sick pay, currently we have a waiting day of 3 days where individuals wouldn't receive any pay on SSP, but that's going to become a day one right. So individuals will start to be able to be paid statutory sick pay from the first day of sickness. At the moment, statutory sick pay is conditional on meeting the lower earnings limit, and that's going to be removed in the future. Therefore, employees will be able to be paid SSP either at the rate of 80% of their normal weekly earnings or the flat rate, whichever is the lower amount. Okay, so other changes, collective consultation during redundancy. So as you will be aware, where you have a collective consultation obligation, which is where you're proposing to dismiss potentially 20 or more employees at one establishment, and I'll talk about the establishment bit in a second, within a period of 90 days or less, you are obliged to follow the statutory collective consultation requirements, because that's what would be triggered. If you fail to do that, then an individual can bring a claim for a protective award. And at the moment, that protective award is the equivalent of 90 days pay. That's going to increase now to 180 days pay. So if you fail to comply with the collective redundancy processes and obligations, then an individual will be able to bring a claim at tribunal for 180 days pay. If we look at the collective consultation, I put this in, even though it's not coming in till 2027, and we're still waiting to hear what the threshold test is going to be. But in 2027, the government are going to be looking at actually what an establishment means. So just by way of a reminder, for those of you who might not know this, At the moment, the obligation for collective consultation is for 20 or more employees at an establishment. And an establishment has been backwards and forwards in the tribunals, but ultimately, under the Woolworths case that happened in 2000, when it was reviewed by the European Courts of Justice in 2015, that's when they looked at what an establishment means. For those of you who aren't familiar with the Woolworths case, at that time, Woolworths went into administration. Ethel Austin Limited and Woolworths went into administration, and each of the different stores were taken as their own unit. And the ECJ agreed that that was the right approach when you're looking at how to consider those who would be under an establishment for the 20 or more, rather than looking at the whole company. So that's what we tend to apply. So, you know, for some organizations where you might have different offices, or you might have different teams, it may be that unit, that team itself, could be considered a unit depending on the circumstances. And therefore, if there's less than 20 within each of those units, the collective consultation obligations don't kick in. It is a little grey in certain areas, and the guidance around it is a little bit subjective. So this is why they're going to be looking at it, I think. So under the new rules that will come in 2027, the government are going to look at what will be considered one establishment, or whether or not they should instead look at a certain number of employees, a percentage of employees that might be affected across the whole employing entity, so the whole organisation. So that piece is going to change, and can, for some organisations, will have quite a significant effect. So if we look at paternity and unpaid parental leave, again, this will come into play from the 6th of April. Paternity leave is going to become a day one right. So the 26-week service requirement will be removed. This is just leave, not pay. Pay will still have that 26-week service requirement. And in addition, unpaid parental leave will also become a day one right, therefore removing the 52-week current service requirement. So you need to already be thinking about your policies to reflect those changes that are going to be effective from April. In addition, at the moment, we have a restriction on taking paternity leave after shared parental leave. So there's an order in which you have to take that leave. That's also going to be removed. So under whistleblowing and NDAs, again, there are going to be some changes in respect to this. So sexual harassment will be set to become a qualifying disclosure under the whistleblowing legislation. So that means that any worker who reports it is going to be protected from any detriment and unfair dismissal. So at the moment, unless you have 2 years service, you can't bring a claim for unfair dismissal unless it's an automatic unfair dismissal, or it sits under something like the whistleblowing. So you could bring a whistleblowing claim and say, I've been dismissed because I brought this whistleblowing claim. So this is going to increase the scope for individuals if they believe that they've been dismissed because they've raised issues in relation to sexual harassment. So you do need to think about updating potentially whistleblowing policies, if you've got them in place, to ensure that they also explicitly cover sexual harassment. And also you might want to look at your grievance procedures or harassment procedures to make sure that they are also aligned with the changes that are coming into play. In addition to that, there's going to be a prohibition of non-disclosure agreements that might aim to gag somebody for speaking up about harassment or discrimination. So at the moment, if you have a settlement agreement or a COT3, if you're bringing a claim, you might put those things in there to prevent someone from discussing it. That's no longer going to be allowed from April 2026. So to help with all of this, the government are actually going to be setting up a Fair Work agency. And this is actually going to be bringing together a variety of different agencies that you may have not even realised were in existence. So at the moment, we have separate agencies, the Employment Agency Standards Inspectorate, the Gang Masters and Labour Abuse Authority, and HMRC's National Minimum Wage Enforcement Team. They're going to be brought together under this new Fair Work Agency from the beginning of April. And they are also going to be given new powers to enforce employees' rights in respect of holiday pay and sick pay as well. So what the Fair Work Agency will do is they'll be able to take employers to tribunal on a worker's behalf if they choose not to action it themselves, and bring a claim. And if any award is made, then that will obviously be paid to the worker on whose behalf they're bringing the claim. I think it's really important to know, obviously HMRC do a lot of focus on holiday, working time, all of those things. And that's only going to increase. So at the moment, in particular, where you have individuals who work variable hours or where it's difficult to keep a track on those hours, you need to really think about how you do that in the future, especially if you end up having an inspection or someone brings a claim. So we have a variety of different obligations under gender pay at the moment. For those who have 250 plus employees, you already have an obligation to report in respect of your gender pay gap. From April, there will be a voluntary requirement for employers who have more than 250 employees to actually also publish action plans in respect of that gender pay gap. And in addition, in respect of menopause action plans too. So this is quite a new piece of legislation that's coming in. Oh, sorry, thought I had a bit more on that one. So there will be voluntary reporting on this in April, but actually in 2027, still waiting on a date for this to be confirmed, there's going to be a mandatory obligation for organisations to report on their action plans and what they're going to do about it. I think gender pay is a really tricky situation because, of course, you're taking such a broad range of employees, and it's not going to be something that's going to be necessarily resolved overnight. But you do still need to be looking at how you might focus on bridging that gap and what your actions are going to be. As I say, it's going to be mandatory for those who've got more than 250 to actually have that action plan in place from 2027. But we are waiting for what that means in terms of kind of the guidance around that. But things you could do now is you can start to look at it. If you fall into this category, you could start to look at that and work out what your long-term plan is. And even for those of you who've got less than 250, it might be something in particular where you have an HR team that you start to consider as well. And a lot of organisations are putting into place menopause policies. If you haven't got a menopause policy, then I would suggest you start to consider that. And it's about education.
Elaine just asked that question, actually, Ros, whether you'd have to put a menopause policy in place. So will that be mandatory, or is that just something people should be thinking about now?
Sure. I mean, I think certainly in 2027, when you have to publish your action plans, I suspect that's going to be something that most organisations will have as part of that action plan. But you can be proactive about it now. So, it's a good thing to start to think
ahead of the game.
Ahead of the game, definitely. There's so much change coming in that getting ahead of the game is a good plan. So already touched on the trade union reforms that are coming in February and April, and there are going to be further reforms in October of this year. And what those are going to be is there's going to be a new obligation for employers to inform workers of their right to join a trade union. So that will either be part of their contract of employment, or potentially it will be a separate letter for existing employees. Again, in terms of what that statement needs to include, we're waiting on the detail behind that, but there's going to be a lot more proactivity in terms of employees and workers being aware of their rights around this. There's going to be some updated rules on a trade union's right of access to the workplace. So they'll be able to request access to meet, support, represent, recruit, or organise workers, and to also facilitate collective bargaining. So this is going to be quite a big change. Not unsurprising with the Labour government, to be honest. There will be a new right for employers to provide reasonable accommodation and facilities for trade union representatives to carry out their duties. So, if you're a large organisation already that has active trade unions, or you recognise trade unions, you may already have these facilities. But again, it's just being aware that this is going to come in as a legislative right. There will be a new right to extend paid time off for union reps to carry out their responsibilities. The government don't believe that at the moment trade union reps have enough paid time off for this, so they're going to encourage more. And there will be, of course, increased protection against detriment for any industrial action where someone might be treated less favourably. So that's coming in October. As I say, we're waiting on the detail behind that. Fire and rehire. So already we've seen some changes around fire and rehire over the last few years. In July 2024, there was a code of practice on dismissal and re-engagement that still stays in place, and non-compliance with that will mean that there could be a 25% uplift in an employee's award if they brought their claim at tribunal, if employers don't comply. We're waiting to see the devil in the detail around this, but there's going to be further restrictions on employers' ability to use a fire and rehire approach, where employees are dismissed for failing to agree to a variation in their terms of employment, and any dismissals will be treated as automatically unfair. Already it's a really difficult one, and fire and rehire tends to only be used in very extreme circumstances where perhaps a large business is suffering from extreme financial difficulties and they might need to vary contractual terms around that. But ultimately, if you've got individuals who aren't willing to accept those changes through consultation, then they're unlikely to accept them on a fire and rehire, and obviously your risk of having claims brought against you are going to be quite significantly high. Further changes in respect of harassment coming into play in October. So employers will be liable for harassment from third parties. So already the legislation refers to third parties, but individuals can't bring a claim under the current legislation on that. But there's actions that companies should be taking where individuals do raise an internal complaint. That is going to be extended. So for employers, if they haven't taken what we deem as all reasonable steps to prevent it happening, then employers are going to be liable for it. And it's not just about sexual harassment, it's going to apply to all types of harassment. So that's quite a significant change. In respect to the sexual harassment that came in 2024, employers are going to have to take what's deemed as all reasonable steps. At the moment, it's just about reasonable steps. So you need to think about what changes you might need to make. So at the moment, under those reasonable steps, you should be training your staff, making them aware about what their obligations are around sexual harassment, the fact that individuals can be held personally liable for any sexual harassment that they might have committed. You need to have robust policies in place. You need to be carrying out risk assessments. So all of those things need to happen now. If you're not doing it, you need to review it. As to what those additional, all reasonable steps are going to be, we're still waiting really for further definition. So although this legislation comes into play in October 2026, in 2027 is when actually they're going to look at the regulations to specify what steps will be regarded as reasonable. to determine whether an employer has actually taken all reasonable steps. So that's extremely helpful, I think, isn't it? This is coming in October, but we're going to have more guidance in 2027. But I think, for my advice to you is look at what you do, assess what your risks are, and make sure you've got robust training in place, you've got robust policies. It's about education. And I think for certain sectors, that's quite difficult, where maybe there is a natural use of banter all the time. It is a difficult one to manage, but you do have an increased risk of a claim if you don't. And we're seeing a huge increase in claims around this area. So let's look at the tribunal changes that are coming into play. So from October this year, employees will be able to bring a tribunal claim within 6 months from the point of the complaint. Currently, it's 3 months. You may have missed it, but ACAS have actually extended their window of conciliation. That was extended last year from 6 weeks. Well, it's 4 weeks, and they can extend that 4-week period to 6 weeks to 12 weeks. So now ACAS have 3 months to conciliate any claim. What that means is that claim is kind of stayed until that conciliation period is completed, and then the individual has a further month to bring a claim. So that's kind of currently where we are at the moment. From October, actually, they're going to have 6 months to bring a claim. I'm not sure how that's going to impact in terms of the ACAS conciliation. I suspect that will be on top of that. So if that is the case, potentially someone might have 9-10 months to bring a tribunal claim from that point of complaint. So no longer do we have that 3-month kind of period where we go, oh, that's it, we're through the other side, no complaints being made, we're in the clear. That's clearly not going to be the case in the future. So just so you've got it on your horizon, really. So the big one, the one that you're probably all wanting to know what this actually means. Well, you would have probably heard or seen in the press anyway. We are now in a situation from January 2027 where an individual will have the right to bring an unfair dismissal claim if they have 6 months service. There will also be a removal of the cap that currently is in place on unfair dismissal compensation. So at the moment, it's the compensation is either the lower amount of 12 months remuneration or £118,000, 233. So but the justification around the removal of the cap is actually it's very rare that actually payouts even hit that higher level. And if you look at discrimination claims, which again don't have a higher cap on, although there is guidance around what should be paid, it's rare that it hits really high figures. So it was felt it was justified to remove it. So I'm not necessarily sure we need to be too worried about that. We'll see how things evolve. But what I do want to do is just take a bit of time to talk to you about this change in the unfair dismissal from 6 months to 6 months. So clearly the clock is ticking now. So up until the 31st of December, someone who has 2 years or less can't bring a claim. 1st of January, that changes to 6 months. Anyone that you employ now clearly will only have from now until December in order for you to be covered under that 2-year rule. But come 1st of January, anyone who's employed between now and the 1st of July could then bring a claim. So you really do need to think carefully about a number of things. You need to think about good recruitment practices, obviously something that Hannah can talk to you about and support with. Making sure that we get that recruitment piece correct at the beginning is so critical. You need to think very carefully about your onboarding, your probation periods, and how we manage that. How do your managers manage that? There's going to be a huge onus on them to manage poor performance. The extension of probation, a lot of companies have a 6-month probation period. You won't be able to have that in the future because anyone who's got 6 months service will be able to bring a claim. So you do need to think about what your probation period should be. And actually, if you're going to extend it, to what point do you extend it? Bearing in mind that if you dismiss somebody without notice, or you're paying them in lieu of notice, the tribunals will add on whatever that will add on a statutory week to that length of service for someone to bring a claim, i.e., so they can, if you dismiss somebody at 5 months and 3 weeks and they haven't worked any notice, then a week would be added on from a tribunal perspective to give them the correct length of service, because they have to take into consideration the statutory week. So really, if you're extending probation, you don't want to be extending it beyond 5.5 months. Otherwise, you may find you could easily tip into this 6-month minimum service. You also need to look at your fixed term contracts. So where you put in place a fixed term contract to cover maternity leave or any of the other family leave, and that's going on beyond a year, that individual will have the right to bring a claim for unfair dismissal if they've got more than 6 months. So you need to follow a process. If you don't have another role for them, you need to follow that process to make sure you've considered alternative roles. I would suggest you probably would consult with the individual towards the end of their fixed term contract to make sure that there is nothing else suitable you can offer them. We can't just immediately go, that's it, we don't need them anymore. You need to really now be looking at your fixed term contracts. Do you have any fixed term contracts which are going to take you beyond the 1st of January 2027? Look at your poor performance. Have we got poor performers? Do we need to do something about that where they've got less than 2 years service? So I think there's quite a lot you've got to consider. And as part of that, you need to think about your managers. Do they need training on this? Are your policies fit for purpose? If you've got a short service clause within your contracts of employment or your disciplinary procedures, then that will need to be removed. So, for example, up to now, we've always put in a short service clause of up to 23 months. We're now just saying that those procedures are non-contractual. And clearly before 6 months, if they're non-contractual, then you don't have to follow them. So there are changes that need to happen now, even though this isn't coming into play to the 1st of January. You just don't want to be caught out, really.
There's another quick question, Ros. So Samantha said that we have seasonal contracts which are predominantly 3 to 6 months in length. Will these need to be changed?
Potentially. So I think you need to look at what the risk is. We need to do a bit of a risk assessment on all of those things. So if there is no longer a role for those individuals after the 6 months, then that's fine. They wouldn't be entitled to a redundancy payment, but you still need to follow a process. So I would meet with them a month before that, explain there isn't anything, consult with them, all of those things, because they could still bring a claim for unfair dismissal. We can't stop that from happening, but it's about whether or not actually whether or not there isn't a role there that they could argue they should be given. So if we look at other changes that are coming in, so tipping, so in particular in the hospitality sector, there has been in place rules around tipping. This is going to be extended from October, so there's going to be a requirement for employers to consult with workers when they're developing their tipping policies. There will be an obligation to review those tipping policies once every 3 years. And in addition to that, individuals will need to be they will need to have shared with them any views which have been expressed during that consultation process, what was said, what the recommendations have been. That can be anonymised as well, those views. You don't have to necessarily show who said what. If they haven't been consulted in respect of the tipping policies, then individuals will be able to bring a complaint at tribunal, and they could have an award of up to £5,000 for financial loss, which has been attributable to the employer's failure to consult. So again, you just need to really think about the impact of this. If you don't have a tipping policy in place, you are in a sector where tipping is normal, you will really need to look at it.
Well, sorry, we've just had a couple of questions. I don't know whether, did you want to do it at the end or shall I just come in with them?
That's okay, come in now, that's fine.
Okay, lovely. So Sarah's just asked whether redundancy payments are staying at the 2-year service.
Yes, we've not heard anything other than, we have not heard that that's going to change.
Lovely. And then just another one from Shelley saying, going back to kind of those day one rights, does there need to be a retrospective change in contracts for current employees or just a
So in respect to the day one rights for paternity and parental leave, then no, you don't need to reissue the contracts. In your contracts, you would normally just refer to family friendly policies anyway. I don't know if there's another day one right that they might have referred to. So unless it's explicit in your contract, you don't need to redo the contract.
It's more the policies that you're having
It's more the
to update.
policies you need
Yeah.
to look at, and good communication. If you've got in your contracts this short service clause, the 23 months, I mean, you don't necessarily need to redo the contracts. It just won't apply. That's all. You just can't consider it.
Hopefully that makes sense, Shelley. But if you needed anything else, obviously feel free to pop it in. She said thank you, so all good.
So things that are coming up on the horizon next year that we don't necessarily have a lot of detail around. So this is kind of quite high level. So the flexible working, there is going to be a couple of changes around it. So it's quite hard to get your head around what's the proposal at the moment. So flexible working will become a day one default right. What we mean by default right is that if someone puts in a request for flexible working, that right is given, unless it's not reasonably feasible. So it's shifting slightly. So at the moment, someone will make that request and we consider that request, and we might reject that request on one of the 6 statutory reasons, obviously following a process in respect of that. The shift is going to be someone puts in, I want to work 4 days instead of 5 days. That's a given. It's going to happen unless you can demonstrate it's not reasonably feasible. So, sorry, the eight business reasons listed in the legislation are going to remain the same. That won't change. But in addition to that, you've got to give more justification around why you believe a refusal of that that request is reasonable. So you're going to have to substantiate it a lot more than you do currently. 0 and lower hour contracts. So this has kind of been backwards. It feels like this has been backwards and forwards for years now, and I'm sure it probably just feels like that. Still not really made lots of final decisions around how this is going to be working, but there will be a right to guaranteed hours in the future for someone who works on a 0 low hour contract basis. The reference period is going to be 12 weeks. I think that has been mentioned before. There may be some seasonal exceptions. So for those of you who have seasonal staff, it might be that sits outside of this, but again, we don't have a lot of the detail around it. In addition, employers are going to have to provide a qualifying agency worker with reasonable notice of shifts on both the employment agency side and also, so you need to let the employment agency know as well as the worker. And there will be an introduction for compensation for cancelled or curtailed shifts as well. So that's going to be coming in, but we don't have a lot of the detail behind that in terms of how that's going to work, but it's on the horizon. Again, for those of you who use a lot of 0 hours or low hour contracts, it's always an opportunity to just review that process. What circumstance you use them. Actually, are they really established employees who work a minimum number of hours anyhow? Maybe they should have a different type of contract. Or if they work on a very ad hoc basis, perhaps they're more of a casual worker. So maybe that's something that you need to look at as well. So I think it's a good idea to kind of review these things. So you're a bit ahead of the game, but obviously we are still waiting on the detail behind it.
And sorry, Ros, just quickly going back to the flexible working. So Caitlin's asked, on flexible working, would further evidence be needed to prove it's not feasible?
It may well be. I think there's going to be a lot more onus on employers to do that. why it couldn't work. And it may be that if you don't currently use trial periods, we'd always recommend that you use a trial period unless it's an absolutely given, we don't think there's going to be a problem with it. But I think the use of trial periods might help you with this to demonstrate whether it can or can't work. There's going to be more trade. Sorry, is that?
Sorry, we've just had one more on the 0 hours staff. So if 0 hours staff are only used to cover sickness and therefore completely variable, how does that sit with the new right?
We just don't know the devil behind the detail on it. But I think if they are very ad hoc, then it may be that they won't fall in under it. And it may be that actually is a 0 hour contract the right contract? Maybe a casual worker contract might be better. We just don't have enough of the detail behind it yet. So I think you just need to look, it's a good idea to just monitor how frequently people work and in what sort of circumstances. If they're working regularly, at least once a week, then they are likely to be caught with this.
Got another one. So Michael said with an accumulative time of 0 hours short contracts, sometimes 1 month, sometimes 2 months throughout the year, does this add up to become a qualifying worker?
I think it depends on the frequency. So if they're working back-to-back months, then potentially yes. If it's purely on a casual basis, so they might work a week in February, or they might work a week at Easter and then a couple of weeks in the summer, unlikely. So I think it just depends on the nature of what they work and when.
Thank you.
So also in 2027, there are more trade union reforms coming in. So the legislation will be extended even further to protect trade union members from discrimination and being blacklisted. And there will be a new industrial relations framework to help employers and trade unions work together. Again, no surprises there under a Labour government. There's also going to be strengthened rights for pregnant workers in that they will, start again. Those strengthened rights are going to give protection against dismissal for pregnant workers and those returning from maternity leave. So it's going to be likely to be unfair to dismiss someone who might be pregnant on maternity leave or for 6 months after that. So at the moment, we've already got that extension. So for 18 months from the start of that person's maternity leave where they can't be dismissed, or that you need to really think about circumstances where they would be dismissed. So they've already got that protection in place. But it seems as if this might be even more where you can't dismiss somebody who might be pregnant or on maternity leave. So I'm not sure how this is going to impact in terms of things like redundancy. So occasionally you get redundancy situations where someone who might be away on maternity leave could be affected. Again, we don't have the detail behind it, but I think there's going to be a lot more that's coming down. I mean, we would always say act with huge caution anyway around this area because of the discrimination issues. There will be a new day one right to take 1 week of bereavement leave. That's going to be coming into play. And there's also going to be a right to take 2 weeks statutory bereavement leave for parents who experience pregnancy or loss before 24 weeks. So that's going to be extending current parental bereavement leave that came into play recently. There's going to be new reporting obligations, but again, we're still waiting to understand what those might be. But it's going to be about reporting on ethnicity and disability pay gaps for employers who have at least 250 employees. And they're going to extend the right to make equal pay claims available to Black, Asian and minority ethnic and disabled workers as well. So that's going to be a new right. The government are also going to review the paid carers leave and consider whether or not, at the moment, under the carers leave, you can take unpaid leave or request unpaid leave, but they are considering whether or not actually that should be paid. So that's going to be reviewed as well in 2027. But again, no times on these things. It's just very much on the horizon in terms of what might come into play. So lots for you to get your head around. As I say, both Hannah and I popped our email addresses into the chat. If you want to sign up for our alerts, we've got an overview document that we can send out to everyone, which shows what the changes are, what actions you might need to take as employers. And you're not on our database, then drop me an email. We can add you to the database and you'll have all the updates. We send out various updates throughout the year. If you need some more assistance in terms of your recruitment processes or understanding how that can be better to help you to avoid that 6-month unfair dismissal claim that might come in, then Hannah can talk to you about the support that they give organisations as well. If you haven't already, if you can pop into the chat any future sessions that you would like us to run, we're just pulling together our programme for the year. That would also be useful, but we will also send out something to everybody as well, I think, Hannah, won't we?
Yeah, absolutely. We've just had a question from Helen. Is the bereavement leave unpaid or paid?
The current parental bereavement leave or the new bereavement leave? So the new bereavement leave will be
both. She's just said
paid.
Both.
Yeah, I think it will be paid, but we're just waiting to understand what that would look like.